goodness, I'm stopped up. All right, give me 10 seconds. I'm doing a couple of checks real quick, making sure everything's good. All right. All right, that's there. Let me go here. Give me 1 second. Yeah, please forgive me. I'm a little stopped up. Also got some food on my mouth. Yeah, please forgive me. I'm a little stopped up. Also got some food on my mouth. Yeah, please forgive me. I'm a little stopped up. All right. All right. All right. Let's get this going. What's up, everybody? This is Supreme Decisions, and today I hope you had an opportunity to look at the title. Can judges rely on facts, not in evidence, to make a ruling? And why am I still hearing this? All right. Now, here's the simple. No, judges are generally not allowed to rely on facts not in evidence when making rulings, especially in jury trials or motions that require findings of fact. Now, motions to suppress, summary judgment, and things of that nature, even your dismissals, there must be something for the judge to actually hang his hat on in order for them not to be held liable for their rulings. Now, one of the things I often tell people to do is get a signed copy of the judge's disposition. Now, why do you do that? Because that is just a piece of paper that holds that judge accountable and liable for their decisions. Because doing so, which is basically relying on facts not in evidence, violates the rules of evidence and due process under both state and federal constitutions. So it doesn't matter which state it's in, it violates your due process rights. Now, why does this matter? Because the courts are bound by rules of evidence, like the federal rules of evidence and also your state organic codes. The Due Process Clause, which is the Fifth Amendment, plus the 14th Amendment, which hold the states liable for the actions of their government. And the right to a fair trial, which is often one of the things that's not pressed enough, and which includes rulings based only on the recorded evidence and admissible testimony. Now, these are things that I'm gonna go over in the master class, which is actual recorded evidence and admissible testimony, because I'm gonna actually go through some prosecutorial tactics which they allow to have things on the record which are inadmissible most of the time because we don't know that it's not an admissible statement. And if a judge uses outside knowledge, bias, or facts not presented and admitted into evidence, notice that if and or facts not presented and admitted into evidence, it compromises neutrality and can be grounds for reversal on appeal or judicial discipline. Now, one of the things that actually brought this up to me is because I actually have a young man that I'm working with, and we're doing like a habeas corpus. The reason being is because a judge and his defense attorney conspired with the prosecution to have him accept a plea which he did not accept, and nor was he present for. And in the midst of doing that, now that we are pressing back about that judge's actions, they're doing things which show that there was an error in their actions because they are attempting to cover up everything that they're doing. Now, even in the context of doing that, there are ways to get these out because what it does, it changes the process in which you have to go through in order to get to the end result that you're looking for, which is the acquittal or being set free, or both. Now, one of the things that you can do to enforce this, if it's during a trial, you can object immediately. And one of your objections will be the court is relying on facts, not evidence, which is a simple objection. And request that such statement be stricken from the record. Because oftentimes you'll hear that whenever you're self-representing and the prosecution say, oh, well, that's not an evidence and I like that statement to be stricken from the record. Now, if you're in front of a jury, what that does is say, hey, that was something outside, but they can't unhear it. And this is also a tactic which is used often by the prosecution because they don't think you know what can and can't be stricken from the record. And another thing, if they do that, make sure the judge actually rules on that objection, because there's a tactic called catch and release, which is one I've used several times, which is not allowing a judge to rule on that objection and just keep moving on, which is like you acknowledge that there was you acknowledge that there was an objection. You then go on beyond and don't allow the judge to rule. Now, what that does, again, the jury can't unhear it, but two, if there's an appeal, it can now not be brought up on appeal. This is, again, why the prosecution uses it, because you can't bring it up because there was no ruling on it. You can only bring up on appeal things that were ruled on. Now, this is one of the things I just told you about. If it's after the ruling, request judicial findings. Ask the judge to state on the record what facts that their ruling was based on. Now, this forces them to limit the ruling to admissible evidence only. Because again, what I found is judges will not put themselves on the line for a prosecutor. They will make a decision, and when they are pressed, you won't get the document that you're requesting, which is that written signed disposition, because that is the one that holds them liable, and they're not going to stand up for any prosecutor. Another one, you can file a motion to reconsider or vacate order. This is something I've done several times, and pretty much taking away a plea that was entered that was not on your own. I don't even understand how you say that. You didn't actually voluntarily enter that plea, so now you can actually withdraw it because it was done by someone who didn't have permission to speak for you. And the argument, the judge improperly relied on extrajudicial or unproven facts. And even in that, the judge ruled without having the ability or authority to do so. You can file an appeal. This is a lot of times what happens immediately after you do the motion to vacate order. The appeals court can overturn decisions where the judge used evidence not on the record, relied on judicial notice improperly, and showed clear bias. These are the most, one of these are the most egregious, and it's also the most common, because even in, let's say, foreclosure cases, judge will use evidence that's not in the record. They will ignore the orders of judicial notice, and they will show clear bias because they're playing big bank takes little bank, because they know the person that they're backing has more money than you do. So they're more likely to side with the person with the most money. And on appeal, including citations on the record showing the judge introduced or relied on facts that were never introduced or testified upon. These are the things that allow you to not only hold them liable, in federal court, also go after them judicially through the judicial misconduct complaints, or even at the state bar level, but you can also hold them liable on appeal. So again, these are things that are just, I'm sharing with you as far as weapons that will be available to you, because I told you before, this is now the era of where we're going to start weaponizing our defense. And then the last part is going to be file a judicial misconduct complaint. Generally, a state has a judicial council for even for federal judges, right? And then the grounds will be the violation of Canon 2 and 3 of the Code of Judicial Conduct, failure to act improperly, and improper conducting in rulings. A lot of times people don't know these canons because they don't go into the crux of holding them liable, because a lot of times we just learn law, but we never understand enforcement. And the enforcement comes on these other grounds through the canons, through their rules, through the organic codes. These are the things that hold them liable, because there's a reason there's a judicial committee. There's a reason that police officers have posts, which is the police officers' standards and conduct of training. That's why they're called conduct unbecoming, or they're call it short cops shorts, call them cubs. Why? Because that cop has an affinity to acting without proper training. Let's use that. Right? So these things are held there so you can notify them, because again, the notification is the setup. These are also the rulings that can force you or help you in your cases that are federally pressed for the most part, whenever you're going to sue. And even when you look at supporting cases, and this is again against the judges, Toomey v. Ohio, the 1927 case, and a lot of people, oh, that's out of date. Well, it's almost 100 years old, but it's still in effect, because I also have another one I'm going to bring up later on today that's 100 and some change. It's an 1800 case, but it was also reinforced, I believe, in 2021 in Georgia. And a judge must act with impropriety or impartiality and the appearance of bias or the use of outside facts, because doing so violates due process. Now, the United States versus Throckmorton, and again, 1878. Rulings based on fraudulent or unproven facts can be reversed. This is why you have the appeals process. Ufot v. United States, 1954. Judges must avoid becoming participants in the proceedings by introducing their own views or facts. These are the things that I talk about when we are saying the judge acted on evidence not, or facts not in evidence. Or we're saying that the judge entered a plea on your behalf. They're becoming participants, because you can either be the judge or you can be a witness. You can't be both. And at that time, there's a different act, because a lot of times you hear people, well, you can't practice law from the bench. Well, that's absolutely true. You cannot be a representative or opposition. You have to be unbiased. This is the origination of that case, why they're saying that, and most people have no idea that's where that comes from. And Lillenberg v. Health Services Acquisition Corp. Failure to disclose or reliance on outside knowledge can lead to reversal of rulings. Now, that's a 1988 case for those that need it more recent. These things are on the books for a reason, and they're there to protect us. So now understanding how to apply them are the things that need to be done in order for us to actually keep moving forward and becoming great at our own defense. So keep this in mind. Judges cannot rule based on evidence, facts not in evidence. And one of the things that you can do, because you want to get the transcripts, what you want to do as a pro se litigant, ask that all rulings be based on the records. The reason why you're doing that is to then make sure you're setting up a foundation for yourself. And then ask, where in the record is that fact supported? Because again, they now have to defend their position. If they choose not to, it is not an option, because just like I told you, they work for you and for your betterment. and they are amenable to you at all times because that is their fiduciary duty, which is why they sign an oath to the trust document, which is the state's constitution as well as the United States Constitution. Not answering that puts you in the driver's seat because of a trust violation. And if they cannot answer, you have grounds for a motion to appeal and civil liability. So give me about 30 minutes. I'm gonna grab something to eat and I'll be back, and hopefully you will too. And we can go over some more stuff because I'm gonna be on here all day. So hit me up if you want to have a conversation, you want a consultation. greatestnow@yahoo.com, and Supreme, I'm out. See you in a little bit.